Welcome back. Attorney Andrew Bethel, Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today, we're talking drama. Probate without a will in a blended marriage. Does the surviving spouse not on title to the house get a piece of the pie, or do the decedent's children get to kick out the step-parent? What does the law say should happen here? Let's find out. So hit the like button, subscribe, share the video with someone you know who's in a blended marriage, and let's dive in. Today's topic is inspired by some real events, but of course I won't be revealing anybody's information, and you should not necessarily take everything I say today and think it will perfectly map onto your situation. Everyone's case is different, and little facts that you might not consider important or pertinent may end up making all the difference when it comes to figuring out who gets what after somebody passes away. In our example case study, we have a surviving spouse, let's call her Anna. Anna's husband Chris has just passed away, and Anna does not know what to do. Both Anna and Chris have children, but they never had any children together, a blended marriage. The house they were living in was in Chris's name alone, and he had the house prior to Chris and Anna getting married, which, for those of you who are already in the know on marital property in California, means that the house would be categorized as Chris's separate property, and he would get to take the house with him entirely should or had Anna and Chris gotten a divorce. In fact, that's what Anna was thinking was going to happen in this case. The same goes for Chris's children. Chris's children were thinking the house would go to them, and they wanted Anna to vacate the house as soon as possible, or for her to start paying rent in order to continue living in the house she'd lived in with Chris for many years by that point. Going further, Chris didn't have a will or a trust. The house was in his name alone. He never put Anna on title with him after they got married because of his experience divorcing his first wife. Thus, in this case, we have to look at the probate code to learn what will happen, which, as you may have guessed, based on everything going forward and the fact that we're talking about this in a video, means it was not as straightforward as Anna or the children thought. In fact, California Probate Code section 6401C3 states that in a case of intestate succession, meaning no will or trust, the distribution of a decedent's property will depend on whether they have children and the character of that property, whether it be community or separate property of the marriage. As I already mentioned, the house in this case was Chris's separate property. In a case where we have a surviving spouse and the deceased spouse leaves separate property in their estate, the surviving spouse does in fact have a claim on a portion of that property, even though it was, as I said before, separate property of the deceased spouse, and had they gotten a divorce, it would have gone 100% to that deceased spouse. The interesting part comes in determining how much that surviving spouse is going to receive. The probate code delineates how much the surviving spouse is to receive based on how many children the deceased spouse left behind. Where the deceased spouse left behind one child, the surviving spouse receives half of the separate property, and the surviving child receives the other half of the separate property, thus a 50-50 split between the surviving spouse and the surviving child. However, where the deceased spouse leaves behind 2 or more children, the surviving spouse is to receive 1/3 of the deceased spouse's separate property, with the remaining 2/3 allocated equally among the surviving children of the decedent. And lastly, where the deceased spouse leaves behind no children or any close familial heirs, then the entirety of the deceased spouse's property is to be distributed to the surviving spouse. I'll put the probate code on screen now so you can pause it and read all the details. Looping back to our example case where Chris, the deceased spouse, leaves behind a surviving spouse and 2 children of his own, the circumstances line up to where Chris will have 3 beneficiaries of his estate. 1/3 of his separate property will go to his surviving spouse Anna, while the remaining 2/3 of his separate property will go equally among his surviving children, of which he happened to have 2, thus each receives 1/3. As you may have guessed, the surviving spouse was surprised and very happy at the revelation of this probate code when she came into my office. She was expecting to have to leave the house essentially as soon as possible, and was concerned because that house is where she had recently built a life with her husband, who unexpectedly passed away. Now in this example, we've only talked about real property, but the rules apply to all property in someone's estate that would be considered their separate property. So in our example case here, Chris also left behind a bank account with some cash in it and a bunch of personal items. So the distribution of that cash and those personal items will also come down to 1/3 surviving spouse, 2/3 equally among surviving children, of which there are 2, again, thus 1/3 each. As a quick note, for community property, that is property acquired during the marriage, That would go 50% to the surviving spouse, thus they end up with 75% of all the community assets. Remember, when we have community property, each spouse has 50%. So when one spouse dies, their 50% gets split 50-50, and the survivor receives half, and the intestate heirs of the decedent receive the other half. Thus, the surviving spouse ultimately ends up with 75%. This community property breakdown also applies to quasi-community property as well. Quasi-community property is property that a couple acquired while living outside a community property state that would have been community property had the couple acquired it while living in a community property state. A simple example is, let's say we have a couple living in New York and they acquire a house or earn income. New York is not a community property state. The couple then move to California, which is a community property state. That house or income is not automatically considered community property, but California law will apply community property rules to said property in cases of divorce or death of a spouse, essentially acting as if it were community property, which the law then calls quasi-community property. In our case study, Chris kept everything separate due to his negative experience from his first marriage, so everything left behind in his estate was 100% his separate property. In our example case, we didn't have many issues besides the initial tension between the surviving spouse, Anna, and the surviving children, but I'm sure you can see or imagine a similar scenario breaking into a large family fight, especially if they were married for only a short period of time, or the surviving children were already much older by the time the surviving spouse came into the picture, and thus there's not that familial tie or connection. Of course, the moral of the story is you should conduct some estate planning to avoid any type of fighting like this and having to rely on whatever the probate code rules happen to be at the time of your passing. In our example case, had Chris created a trust of his own, entitled his house and other assets into it, we would have avoided the entire family fight in the probate, which, you know anything about probate fees in California, attorney fees are very high and ostensibly fixed. In this case, my attorney fee was in the ballpark of around $11,000 or so. Additionally, adding all the court fees, that brought the total out-of-pocket cost for the family to approximately $14,000. I hope today's video helps set the idea that doing nothing only creates a problem for everyone in your family and allows more of your estate to be eaten up by fees. But what do you think? Do you know anybody who's playing it a little fast and loose with their estate planning? Send them this video to spring them into action. Be sure to like and subscribe, drop a comment below if you have any questions or a topic you want me to cover. I'm Attorney Andrew Bethel, and I'll see you next time.